Good afternoon, everyone, and thank you for joining us today in our roundtable discussion on data privacy. And my name is Carrion. I am a law practice management advisor at LCL. Thank you for joining us again. And today we have a great panel of experts that are going to talk about data protection in Massachusetts. And I would like to start by doing some brief introductions. You can read more about our presenters' bios in the page for this program. We have today with us Jared Rinehimer. He is the Chief of the Data Privacy and Security Division at the Massachusetts Attorney General's Office. He is the Chief of the Data Privacy and Security Division, and he also was a founding member of that division when it was created in 2020. He has been responsible for numerous data security investigations and related litigation on behalf of the Attorney General's Office. We also have with us Clinton Dick, who's the General Counsel for the Office of Consumer Affairs and Business Regulation. Clinton has worked for the Commonwealth for over 16 years in various capacities. He now, as General Counsel, helps to ensure that legal requirements for data breach notifications are met by companies and individuals. And we also have with us Brooke Schofield. She's a legal intern with Clinton at the Office of Consumer Affairs. First of all, thank you, Brooke, for the presentation for today, the slides. Great job. And Brooke is at 2L at Boston College Law School. She's, like I said, interning with the Office of Consumer Affairs, as she has worked with the hearing officer on dismissed complaints. She conducts research, and she helps to maintain information regarding current complaints. And thank you again, Brooke. And with those introductions, I'm going to pass the platform to Clinton. Clinton, take it away.
Thank you very much. We are very happy to be here. I think it's an important program that both the Office of Consumer Affairs, which you'll hear me just refer to as a COBRA, just our long name shortened for your pleasure, and as well as with the Attorney General here. Attorney General's office, Jared representing them. So what we put together for you all is some slides that we hope will help to make the program and the responsibilities and requirements more understandable for what may be for many businesses, solo practitioners, small firms, first time they're going to be encountering a data breach and what they should do. So you'll hear me also ask Brooke to move slides forward. These are in her trustable hands. So Brooke, could you go to the next slide, please? So yes, as you'll learn through the presentation, there are both the Office of the Attorney General and the Office of Consumer Affairs have responsibilities with respect to data breach notifications. So there you see Attorney General Campbell along with Undersecretary D'Amelia, who lead both offices respectively. Next slide, please, Brooke. So, we hope to cover a few topics today. What are your responsibilities if there is a data breach? What kind of notifications need to be made? What is the data breach program? And what are your responsibilities both to OCOBRA, and that should also say, and the Attorney General's office. Next slide, please. So briefly, the Office of Consumer Affairs and Business Regulation sits within the Executive Office of Economic Development. We oversee ourselves the Lemon Law and Lemon Law Arbitration Program, which, if any of you have had the unfortunate experience of having to do that, means your car may have been sold to you in a way that's not in compliance with the law. And we do data breach reporting, and as you'll see, we make those available on our website. And for individuals who make those requests, you can see what the actual data breach report is that was sent to us. We also oversee home improvement contractor programs. These are individuals who do remodeling. We handle complaints, arbitration, and guarantee fund, meaning we try to get folks back some money if they're unable to do so from a contractor who messed up. And then finally, probably our smallest program is we do the do not call registry, which, where I think we're all familiar with. You put your number in, and hopefully telemarketers respect that and don't reach out to you. And next slide, and I think this is where I will hand it over to my colleague, Jared.
Hi, thanks for having me. So I think it's a little useful to kind of cover a little bit of the organization of the AG's office. So first, obviously, we have the Attorney General at the top, and there's really sort of three big functions of the office, right? One is doing policy and advocacy work, which we do with the state legislature, as well as federal officials and just general advocacy work. One is the state legal defense work that we do with the government bureau within the office. And then the other that I think a lot of people associate with the Attorney General's office, although primarily in the criminal capacity, is law enforcement. My division does primarily what's called civil law enforcement work, focused on, in part, Chapter 93H and the breach laws. We can go to the next slide. So here's the organization of the office. There's different bureaus, and they obviously have different functions. My division is in this Public Protection and Advocacy Bureau, which, if we go to the next slide, I'll show you, is divided into a number of divisions, which include ones that people are pretty familiar with, including consumer protection, civil rights, and fair labor, but also other divisions like insurance and financial services, our team of civil investigators, and the consumer advocacy and response division, which handles consumer complaints and tries to work with companies on resolving those complaints. And then there is the data privacy and security division, which is where I sit. We'll go to the next slide after that. So what do we do in our division? We primarily investigate and enforce the data protection laws and privacy more broadly. And we'll talk about those laws in a little bit. We also, to the extent there are proposals or particular legislative initiatives that come up, or regulatory initiatives that come up, we will present the office's views on those. For instance, last year, Massachusetts and a number of other states put together some comments to Congress about pending privacy legislation before Congress, and then sent a letter as a group to them. And then the last thing we do is what I'm doing now, where we work with businesses in the bar and consumers to sort of educate them about what the law is and what we do. So I'll go to the next slide after that. So there are, 4 basic laws that our office enforces that really apply in this context. The first is the data breach notice law, which is Chapter 93H. That requires you to notify when there is a breach of personal information, and what that means exactly we'll get into. Then there are the data security regulations, which are relatively unique to Massachusetts, and those are put out by the Office of Consumer Affairs, and those concern the duty that you have to protect and secure that personal information, involving putting together a plan to keep that information protected. There's the data destruction law, which is Chapter 93I, which talks about a duty to dispose of information when it's no longer needed. And then sort of overarching among all of these is what's called the Consumer Protection Law, Chapter 93A, which broadly bans unfair, deceptive trade practices. That is the primary way that the Attorney General's office does investigations and looks into practices. So we can go to the next slide after that. Okay, and I'll pass it back over to Brooke, I believe, right?
Thank you, yes. So starting off from the Massachusetts General Laws, Chapter 93H is the data breach notice law. So this is covering a breach of security, which is the unauthorized acquisition or unauthorized use of encrypted data or encrypted electronic data, and the confidential process or key that is capable of compromising the security, confidentiality, or integrity of personal information. And this would be maintained by a person or an agency that creates a substantial risk of identity theft or fraud against a resident of the Commonwealth. So personal information is involved in security breaches. So you can see here what constitutes personal information. It's made up of two elements. So the first is the resident's name, whether that be the resident's first and last name or the first initial with the last name. And that's in combination with one or more of the following data elements, whether that be social security number, a driver's license number, a state issued identification card number, or a financial account number or credit card or debit number. There are security data regulations, which are covered under 201 of the Commonwealth of Massachusetts Regulations, Section 17. So this regulation outlines the duty to protect and secure personal information. It establishes minimum standards to be met by persons who own or license personal information about a resident of the Commonwealth of Massachusetts in connection with the safeguarding of personal information, which can be contained in both paper and electronic records. And this ensures the security and confidentiality of customer information in a manner that is fully consistent with industry standards. And it also protects against anticipated threats or hazards to the security or integrity of such information. And lastly, it protects against unauthorized access to or use of such information that may result in substantial harm or inconvenience to any consumer. So notice must be provided when a data breach occurs. A person or agency that owns or licenses data that includes personal information about a resident of the Commonwealth shall provide notice as soon as practicable and without unreasonable delay when such person or agency knows or has a reason to know of a breach of security, or when the person or agency knows or has reason to know that the personal information was acquired or used by an authorized person or used for an unauthorized purpose. So in short, there are two triggers for notice, the first being when a breach of security occurs, and the second being when an unauthorized acquisition or use occurs. Consumers cannot file for data breaches. Data breaches can only be filed by the person or agency holding, maintaining, or storing the data for the consumer. And notice of the breach or the unauthorized acquisition of the information must be sent to three places. First, the Attorney General's office. Second, the Undersecretary of OCABRA. And third, the resident or residents whose information was affected. The notice to the Attorney General's office must include many things. The first, the nature of the breach or the unauthorized acquisition or use. The second is the number of Commonwealth residents that were affected by the breach. The third is the name and address of the person or agency that experienced the breach. Next is the name and title of the person or the agency that is reporting the breach, as well as their relationship to the person or agency that experienced the breach of security. The type of person or agency reporting the breach, the person responsible for the breach of security, if that's known, the type of personal information compromised, whether the person or agency maintains a written information security program, which will be talked a little about later, any steps the person or agency has taken or plans to take relating to the incident, and the sample notice that it is sent to the affected residents. The notice to the consumer should include the resident's right to obtain a police report, how the resident may request a security freeze, as well as the necessary information that should be provided when requesting the freeze. There should be notice that there shall be no charge for the security freeze and no fee for credit monitoring for 18 months. Mitigation services to be provided. The notice shall not include the nature of the breach of the security or the unauthorized acquisition or the number of the residents of the Commonwealth affected by the breach of security. Basically, this notice works to make consumers aware of free credit monitoring services. And in that notice, specific language must be mentioned to the consumer, and there's a sample provided here. So at the time that the notice is given, even if the total number of residents is not determined, the notice provided to the resident shall not be delayed. And in which case that the number of residents is not yet ascertained, the person or agency shall provide additional notice as soon as practicable and without unreasonable delay upon learning such additional information of another number that was affected. And OCABRA will, after receiving notice, make available electronic copies of the sample notice that's been sent to consumers on its website, and it will post such notice within 1 business day upon receipt from the person that experienced the breach of security. OCABRA will update the breach of security notification report on its website as soon as practically possible after the information has been verified by said office, but not more than 10 business days after receipt, unless the information provided is not verifiable, provided, however, that OCABRA shall post said notice as soon as verified. OCABRA should amend on a recurring basis the breach of security notification report to include new information discovered through the investigation process or new subsequent findings from a previously reported breach of security. And finally, OCABRA should instruct consumers on how they may file a public records request to obtain a copy of the notice provided to the Attorney General's office in the Office of Consumer Affairs and Business Regulation from the person who experienced a breach of security. So the data breach report website for Massachusetts has recently been updated. Here, among other things, you can report your new data breach, update your existing data breach report, and find requirements for data breach notifications. And that link to the data breach report website is listed here. Data breach reports are available on the MassGov data breach website. Here are just directions how to get there, or you can Google or search mass data breach, and that should come up for you. Here is an example of a report of a data breach, and these are available by year on the data breach website. And for data breach and law enforcement, notice may be delayed of a data breach or unauthorized use if a law enforcement agency determines that provision of such notice may impede a criminal investigation, and they have notified the Attorney General's office in writing, and informs the person or agency of such a determination. If notice is delayed due to such determination, and as the law enforcement agency determines and informs the person or agency that notification no longer poses a risk of impeding an investigation, notice shall be provided as soon as practicable and without unreasonable delay. Finally, the person or agency shall cooperate with law enforcement in its investigation of any breach of security or unauthorized acquisition or use, which shall include the sharing of information relevant to the incident, provided, however, that such disclosure shall not require the disclosure of confidential business information or trade secrets.
So we also wanted to spend a little bit of time just talking about Chapter 93I and what it requires. This particular chapter is separate from the breach notification requirements in Chapter 93H, and it requires you to destroy personal information. That's, again, name plus social security number, or name plus financial account number, or name plus government ID or driver's license number, both for paper records and electronic records. And so here I've sort of quoted the very specific language that's in the statute, but for paper records need to be either redacted, burned, pulverized, or shredded, and electronic media needs to be destroyed in such a way that the personal information cannot practicably be read or reconstructed. So just keep in mind those requirements. Occasionally, our office will also take action under Chapter 93I in addition to Chapter 93H. We can go to the next slide after that. So a little bit more about the data security regulations that we talked about above. They require a company who has personal information to develop, implement, and maintain what we call in our office a WISP, or Written Information Security Program. The actual language in the regulation says an information security program written in one or more parts, I believe. And it has to be appropriate to the size, scope, and type of business. But in addition to that requirement, there's also very specific technical requirements relating to encryption of portable devices, firewall requirements, regular updates to your software, things like that. We can go to the next slide after this.
Sorry, one moment.
That's okay. Sometimes just needs to think a minute.
There we go.
Oh, did we skip one, or did I just make that up? Nope, go for it. Okay,
I think you might have one coming after this.
Yeah, that's it. Okay. So I think, one of the things that I think people wonder is, well, what does the AGO in particular do when we get these notices, right? And so our office reviews all the notices that come in. We will review them to make sure that the terms of the statute are complied with. So we want to make sure that the notice to the consumer is accurate. It gives out accurate information. Some of the areas that we get particularly concerned about are information about security freezes. And so you should be telling folks in the consumer notice that the security freeze is free. That was recently added to the statute back in 2018, because before that time, security freezes used to cost $5, or they were capped at $5 as mandated by state law. We occasionally see some notice letters that still mention the $5, and if we see that, we will usually reach out to the company either in writing or by a phone call to let them know, that language isn't necessarily accurate, needs to be fixed in order to encourage consumers to put these protective measures in place. We also look to make sure that if Social Security numbers are affected, that the credit monitoring that's required under the statute is provided. And again, that's 18 months of credit monitoring if you're not a credit reporting agency. If you're a credit reporting agency, it's like 3.5 years, I think. So in the more serious circumstances, say if notice is extremely delayed, or if there are real concerns about compliance with the data security regulations, our office may either informally or formally request more information from the company. And that is done through what's called a civil investigative demand. It is issued under Chapter 93A, the Consumer Protection Act. And those civil investigative demands are, in effect, subpoenas for information, sort of outside the context of any litigation, where we will often ask for documentation about the incidents or about the security measures that the organization had in place. We rarely file a suit before issuing a civil investigative demand. Most notably, I would say that in the Equifax matter, we sued pretty quickly after the incident was announced. I would say that's relatively rare. But the office does have the authority to, and by the way, in Equifax, we also issued a civil investigative demand. But it's pretty rare for us to file suit. Usually we will file a civil investigative demand first to ask for information. In the event that the office is of the opinion that there may be some legal violations going on, we would seek some sort of a resolution through what's called an assurance of discontinuance, which is a vehicle in Chapter 93A that allows a resolution to be filed in the Superior Court without initiating a civil action, or through a consent judgment, which is where a complaint is filed and the judgment is filed right at that time. One other thing that's just worth noting is that a lot of the state AG's offices know each other and communicate with each other. And so on the cases where there are larger incidents that may go across state lines, sometimes you will see cooperation among those state AG's offices to investigate the incident and also resolve it. And we can go to the next slide real quick. So one thing that just thought would be useful to present to folks here are some of the resolutions that are, this is not all of them, some of the resolutions that our office has reached in recent years, for the most part, except for TD Bank, which is from 2014. But the most recent case we had was a case against a company called Arbiter Sports, which resolved in just a few months ago, back in early December, I believe, which involved that was one of the first matters where we got over $1 million, aside from the Equifax case. That was a situation where the company did not maintain the WISP in the way that you would want to see. There's another matter that's Commonwealth versus Multi-State Billing Services, where there was no WISP entirely with the company. There is a recent resolution with a company called Aviana, which provides home healthcare services in Massachusetts and in other states. There is a very interesting case under Chapter 93I involving Mr. Haney, who was an attorney in Massachusetts, and some of his files were found, I believe, on like a client's farm. There's a report about it on the news, and it was just client files kind of sitting in boxes out in the open that people could access. And that's a good example of a Chapter 93I case. The documents were not disposed of in the appropriate manner. It's worth keeping in mind that if you are a vendor to someone else and hold their information, that does not necessarily mean that you don't have responsibilities under the law. Most recently, there was an incident at a company called Blackbaud, which hosted a lot of donor databases for various nonprofits throughout the country. And that was one that was settled by a large multi-state group working on that case. Very large incidents like Equifax settled a few years ago. And then one final one involving encryption of backup tapes. So portable device encryption, which I think used to be a lot bigger problem than it might be now as people have kind of moved to cloud storage. But if you do have, flash drives or laptops, make sure that they're encrypted, because that is one of the requirements of the data security regs. So with that, I think that's everything from me. I'll pass it back to Brooke and Clinton for anything else.
Yeah, no, thank you. Yeah, obviously, if there's any additional questions, I can certainly, make it easy to reach me. I don't think we put it here, but we could make that happen if there are folks who need to reach out later, who may have questions. We have folks who are more knowledgeable about the day-to-day and the filing at our office, what needs to be done, how to file it. But I can help facilitate that. And I just wanted to end by kind of putting it in context for folks too, in terms of data breaches. So on our reporting on the website where we have these reports, there was 428 breach notifications in 2008, affecting 700,000 people. And then last year, there were 2,400 breach breaches affecting 7 million residents. These are just residents of Massachusetts. So, you know, I certainly I think we're all aware that this has become more of a problem. I hope too, though, that increase maybe because businesses and individuals became aware and did the breaches in compliance with the law. So I don't want to say it's all misuse or whether malicious or not, or unauthorized acquisition. But I do think I myself have received plenty of letters over the years, and you can become almost numb to it. But it's important to a lot of folks. Like we get our public records office probably has the most requests from individuals seeking the breach notifications. They want to make sure the letter they received was real, or sometimes, you know, they may have received a letter and we don't have a corresponding notification to us, which can happen, which allows us to then reach out to the company. And we always try to be cooperative. We always try to make sure they understand what their requirements are and get them into compliance. Not here to be heavy-handed, though certainly that will happen. I mean, if need be, and our friends at the Attorney General office have that enforcement capabilities. But we just want to make sure that you all are at least, you know, beginning to understand, beginning to think about this, in the unfortunate situation where this happens to any kind of business organization you're associated with, whether it is a mistake or worse, in my opinion, is, you know, some kind of attack, so to speak, some kind of blackmail, some kind of unauthorized use in its worst sense, which we all know happens and can shut down organizations, towns, cities. And that's why I think it's important too that there's the law enforcement component there. I mean, we want to work with ourselves, especially we're not law enforcement here at OCA, so we want to work with law enforcement to make sure that they're able to do what they need to do, while also ensuring we're trying to get the information out to consumers as fast as possible. So I just wanted to end with that, but again, let us serve as a resource to you. So thank you.
Thank you so much, all of you. We do have questions and we have time for questions.
Yes.
And we actually have one question.
Yeah.
And I do would like to have a brief conversation. So let me read the first question that we have. And I invite, actually, by the way, I invite everyone who's attending to enter your questions in the chat section in your Zoom platform. The question is, what does owning personal information mean? Just that it's in my is that just information that's it's in my files? Does a sole practitioner need to have a WISP? Very good question.
Yeah, so I would you know, I can start out, maybe I'll take the first part, Jared, if you want to take a step. But yeah, it's owning is, you know, you have that information. So for your clients, even a solo, you know, you have the information in a file. You're responsible. You may have solicited it or you may have received it. But if it's within your possession, I would say for almost the vast majority of instances, that would be ownership, and your responsibility would be to protect it, not disclose it.
And as for having a WISP, you know, the law applies to anyone who owns or licenses personal information in Massachusetts. And so, you know, to the extent your sole practice has information that falls under this definition, I think, you know, having a program is something that should be considered. I can't obviously give you like legal advice for your specific circumstance, but I think, you know, some people get concerned about the terminology written information security program, but what would be expected of, say, a smaller organization is going to be very different from a, you know, multi-state, multinational corporation, right? And so the important thing to keep in mind in the WISP requirements is that it's appropriate to the size, scope, and type of business. You may also find that a lot of the things that you already use enable a lot of the practices that are required in the regulations as it stands. And so the general answer to that question is yes. Yeah, I mean, any company that has personal information should have one of these in place. I know that, like, for instance, the International Association of Privacy Professionals has put out a sample WISP. I'm not endorsing it, but that may be a place to start if you want to think about it. No guarantees that it meets the requirements of the statute, but I know that there are some people who have put out these samples that you can start with if you want.
Thank you. And so, for example, a solo practitioner who handles financial information from, let's say, a divorce case where they have to provide, they have to handle bank account records, that contain, let's say, a checking account number and so on. That would be considered personal information if it's attached to the name and the last name of the client, correct?
That's correct.
Yes, so
Yeah.
that will be an instance where a solo practitioner will be owning or holding that personal information, and that's where the WISP requirement kicks in, basically. So if a solo practitioner is holding that type of information, like driver's license, you said, Clinton, or government issues IDs, and you can tie it to a person's name or initial and last name, then you're a holder or you own that personal information, and you're required to comply with the by having a WISP. And so a few things that I wanted to point out as takeaways. It looks like the AGO is asking for WISPs, for the production of a WISP, if there's an investigation that results out of a data breach notification. So you should have that WISP ready, because correct me if I'm wrong, Jared, that could be an issue. As we saw in the sample cases, not having a WISP could become an issue with your office.
Yeah, so I think what I would say to that is, as Clinton pointed out, there were thousands of breach notices that we receive every year. Our office does not, do enforcement actions for every, all of those particular notices, right?
Mm-hmm.
One of the things that's now required under the law is that you need to, when you file the notification with our office, which for both Office of Consumer Affairs and Business Regulation and the AGO, we have online forms that you can fill out. One of the things that you need to tell us is whether or not you have a WISP in place. And if you say no, then, in some circumstances, depending on the severity of the incident, we may look into it more deeply, but more often than not, what we will do is tell you need to have a WISP, usually with a letter by saying, we noticed that you said you didn't have one. Just be mindful that this requirement exists. We are not, we may not necessarily ask you for it. There's some degree of like prioritization that we do with respect to incidents that happen with the office, right? So it's not, we're really focused on the ones that seem to be very harmful or represent really extreme oversights by particular organizations. Those are the ones that we really take a lot of enforcement action with. But, if folks are worried that their like small business is going to be subject to an enforcement action, I think that may not always be the case. So just keep that in mind. There were a few other questions. I don't know if you wanted to.
Yes, I wanted to address.
Okay.
Yes.
Yeah.
Thank you. Thank you for that great answer,
Sure.
Jared. So one of the questions, will the copies of the slides be distributed? Absolutely. We're gonna do that. What we do is that we make the recording available. We will send you the recording with the slides and resources, and you can access everything from that email. So the next question is, what advice do you give a nonprofit about complying with data security laws and breaches? How does a small nonprofit manage everything that is required, especially after a breach? Most of us barely have resources to serve our clients, so a breach may destroy a nonprofit, especially the expenses to comply. I would say, just to get it out there, that if you're a subject of an authorized data breach or some sort of unfortunate event like a ransomware attack, please seek the advice of counsel. It's always good to have an attorney. There are attorneys out there who specialize just on this, on handling data breaches and the notification and investigation process. So please seek advice of counsel, and then I will move it to Clinton and Jared to answer that question.
Sure. I mean, I think it's a good one. You know, it's it can seem daunting, certainly, I think. Especially, I think Jared referenced the model list out there, which I know we're not endorsing it, but it's, you know, it's, in my opinion, very, very comprehensive. So, and I think it was one of the slides talked about the WISP, but kind of in relation to what kind of ownership of or licensing of information you have. So, you know, certainly look at the law, but I would start with, okay, I need to protect personal information. What am I doing for paper? Am I locking up file drawers? Am I limiting access to folks who just need to know? Am I treating personal information maybe as I instinctively treat a personnel record, which is, you know, no one has a right to that other than the people in the chain. Treat the personal information the same. And then you move to, you know, the electronic, which is obviously, I think, the more vulnerable. And there, you know, I think you just have to, you know, what you want to do is comply so that the breach doesn't send you under. And what I mean by that is if you do have a breach or an unauthorized acquisition, that can be, you know, certainly devastating. And so I would encourage folks to look at compliance as stopping that kind of serious and potentially, you know, fatal to the business or nonprofit breach that could take you down, could cause clients or folks you interact with, grantors, you know, to lose trust in your ability to hold money, to hold information about individuals. So see this as, and I know as regulators it's easy to say, but do see this as a tool. We require this because we know that it can be devastating to an individual if they've been the subject of identity theft. It can cripple or stop for a period of time insurance if there's a breach and they have to basically slow roll or stop payments to hospitals. Towns get blackmailed. And it really is like a preventative first measure that I hope, my goal is for folks to see that as a value to their nonprofit or business, recognizing that the work that goes into it. But I think it should be seen as a tool to help their nonprofit and business grow.
Okay. And I'm sorry, Jared, were you gonna say something?
Yeah, I think one of the things that I think has been increasingly common is for folks to have insurance policies that cover things of this nature. And so that may be something worth considering. We certainly get a lot of breach notices from law firms that are often hired as insurance data breach counsel specifically to review things. I think a few other things worth considering are know what information you have. Often the costliest part of doing a lot of these reviews is finding out what information was affected, right? And that is typically because if, say, somebody's email account is, you know, hacked, then somebody manually has to review that email account for all the different types of information that may have been sent. be it social security numbers, which shouldn't be sent over email anyway, or credit card numbers or copies of checks or things like that. So it's good to get organized, think about what people have, set some really strict policies around, how you accept payments, whether you even need to be taking people's social security numbers, for instance, and how long you keep that information, right? You know, Destroying information is important too, because you can't be breached for information that you don't have, right? And so that can also help limit some of the issues that may come up down the line. So, and that's one of the purposes of having, this plan in place, is to help prevent against the incidents, but also help to mitigate against the potential harms if something does happen.
Thank you. And we have a few more questions, very good questions. So some people or organizations don't even realize they were the victims of a data breach, such as, phishing or spoofing. So would you suggest people in such situations to seek cybersecurity professionals first to assess or confirm whether a breach took place before contacting your offices? Or should they just contact your office even if they're unsure that a breach took place?
I mean, just, am I on mute? No, I would just say for consumer affairs, which I hope people are saying, we do have a little bit of we have different roles. We have overlapping, certainly Attorney General, but I think ours is more of a notification. So we are looking for, because what you're really telling us is we know of a breach for our purposes only. We know of a breach. We're sending a letter to the resident or the residents who are affected, and here's the nature of it. I'll let Jared, I think, speak a little bit more, maybe about, if he would like, about how best to ascertain it. If you do think you're the subject of it, I mean, law enforcement is a great place to start, to make them aware of that, filing a police report. And, I do think paying attention to phishing versus actual would require some type of due diligence if you are seeking to, make sure the breach is real and not then subjecting yourself to a breach by thinking you're responding to a breach. So that from our point of view, again, just as a receiver of information only, would be my response.
Yeah, I think, as far as, so there's sort of a difference between the formal notification that the office gets versus, like, someone who might be informally calling the office about, with specific questions. There's only so much we can answer. I mean, we can't, serve to give you advice necessarily of how to respond to the incident. That is kind of beyond the scope of what, I would say that the office's role is in this particular process. Our process is to make sure that people are notified, make sure that the security policies were in place if they needed to be, or if they aren't, are going to be put in place. But one of the things that, I think we would be, it wouldn't quite be right for us to assist you with, is how to actually respond to the incident and identify the information. We may ask you some questions about it, but I think usually, it makes sense to check in with some other folks. I like to think of it sort of, like the AG's office responsibility is really focused on whether the organization or the company did what they needed to. Often, the FBI, US attorneys, folks like that are really focused on the bad actor who is doing that. And so if you kind of think about it from that separation point, that may help sort of guide who you want to contact or reach out to.
Mm-hmm. Thank you. And there are professionals out there, experts in cybersecurity, who would that have those services, for example, to assess whether you were the victim of a data breach. And there are also services provided by those firms in terms of doing like cybersecurity assessments, penetration assessments to see whether your devices are vulnerable or for an attack. But definitely, yes, those services are out there. You can always call LCL. You can schedule an appointment with us. We can talk about those type of services. We can talk about in more detail. For example, on a WISP, we can help you with that process and guide you through that process and point you in the right direction as well if you need more expert assistance with regards to that technology and cybersecurity. The next question, we keep getting questions, oh my gosh, so we have to go through all of this quickly. We're running out of time. Would it make sense to include your WISP with the notification to the AG's office?
I would keep in mind that the things that are sent to our office are often public records. And so I would probably not encourage people to send their WISP to the office unless we ask for it, because if there is some rare instance of public records request, it might be that we have to then review it to review if it's something that is actually producible under the public records law or not produced. Typically there is like an exemption that can be invoked for cybersecurity things such that they may not be produced, but I can't guarantee in every instance that that's going to apply. And so I think I would say that there's no need unless we ask for it.
Mm-hmm. Thank you. Next question. For small enterprises, it makes sense to call their insurance agent, assuming they have cyber security or cyber insurance protection first, since their coverage may include right to counsel who can help with post-breach work. So that was more of a statement, not a question. So, and I do agree. It could, if you have cyber insurance coverage, it's absolutely a good idea to contact your carrier when these incidents occur. Then we have the next question is to follow on Jared's comment. Have their offices come across examples of cyber insurance policies? Oh, hold on, I just got another question. Of cyber insurance policies that are more comprehensive, suggested than others? If I may, before you speak, Jared, I just want to let the community know that we have a webinar for busy lawyers on cyber insurance. I will include the link to that webinar with the resources that will be contained with this recording. So we do have some information on cyber insurance for LCL, but Jared, have you come across examples of cyber insurance policies that are more comprehensive or suggested than others?
Yeah, I mean, I don't think I can endorse any particular insurance products, but and frankly, like we often don't know because the information that we receive is typically what's required under the statute. So it's not, it's usually not the case that like counsel is saying, oh, we were hired under this policy or whatever. And often it's the same firm under many different policies, I'm sure. So hard to tell.
Okay, and then we have, it looks like the last question. Oh no, actually, I went through all the questions already. Thank you for those great questions to the audience. And thank you for joining us. And thank you for a great panel discussion to all of you. And like I said, you will receive an email with the recording and additional resources. And we will also post this in our website. And it's available at anytime, 24/7 and for free. Thank you for joining us and have a great day.
Thank you. Thanks very much.
Thank you.
Thank you.
Thank you all. Great job.